Good evening. Thank you very much for coming to Modern Families Thoughtful Wealth. It's been a few months in the making, the construction of this evening. My name is Megan Simpson. I'm a partner at Sunnydale Family Wealth. We have the rest of the panel here with me. Is comprised of Kaylee Rod. She's from Barristan Law. Kaylee is a real estate and corporate lawyer and estate. She does estates as well, so she's going to be providing some expertise in that area. Blake Emmett is one of my partners. Blake is a CPA by trade. He is also a relationship manager, so he works with clients and their families directly, but he also oversees all of our tax sort of activities and strategy for all clients. We've got Hillary Goodman from Barristan. Hillary is a partner and a family lawyer, so she's going to weigh in on all of those sort of family idiosyncrasies and where we can work some proper planning into families' lives. And last but not least, we've got Graham Ferguson. Graham is also one of my partners at Sunnydale. He is a relationship manager as well, and he also leads all of our financial planning and long-term protection activities for the team. So that's us in a nutshell. There's more information in the handout if you had other questions or wanted to learn a little bit more about us. There's a lot of different ways we could have organized this evening. We batted around several different concepts and ideas, and we ended up landing on using a case format. So what we decided to do is we've built a hypothetical family tree covering 3 different generations. But every family is unique, and so we're maybe not going to touch on something specific that you were hoping for us to address this evening. So, the objective is to get you to start thinking a little bit differently about your long-term planning and the structure for your family. And if we don't touch on something that is a key point for you, we've got some time at the end of this evening to have open dialogue, or if you want to reach out to us after the fact, we're all available to answer questions. So no 2 families are alike, so the planning also shouldn't be the same. So here we go. This is our Smith family tree. So at the head of the family, we've got Paul and Margaret. They're in their 80s. They've got their 2 children, Susan and Robert. And then there's 4 biological grandchildren as part of the family. So the hope is that there's some concepts in here that are going to resonate with you and your own. So we're going to start. I'm just going to go over a few high-level details about the background for each of the different generations. So we've got Margaret and Paul. They've been married for a very long time. They have amassed some significant wealth throughout their lifetime. They had some really, really good planning put in place at the time. A few years ago, they transitioned the family business over to their son, Robert, so that planning has been done. They're retired, living quite comfortably. One of their main goals is they would like to be able to help their children or grandchildren during their lifetime so they can see some of the benefit and enjoyment of those gifts. They don't want to save it all to the estate and then not see some of that happiness. They are a little bit concerned, I shouldn't say a little bit, they are concerned over the transition of their family cottage. It's something that all the generations enjoy, and that's can be a tricky topic for many families. But more than anything, they want to treat their children and grandchildren fairly. So that's the matriarch and patriarch of the family. Next we have, in terms of the first part of our second generation, we have Susan. So Susan is divorced. She has 2 children from her marriage. They are both adults. And she's got a long-term partner named David, who also has children from his first marriage. Now that the kids are kind of approaching almost completely independent, they are talking about moving in together. But they both own their own home and they both have their own assets, and their intention is to keep all of that separate from one another, but they don't intend to get married. The big goal is to be able to pass on their assets to their own children and protect that wealth within their own family bloodline. Next, we have Robert. So Robert is married. They have 2 adult children. As I mentioned before, the family business was passed to Robert, so he is now the sole owner operator of the company. Loves his job, loves working with his son Alex, who is being groomed to take over the reins eventually. He has recently encountered some health issues, so that's really brought some planning to the forefront for him personally. That maybe that some transition, or either through leadership and being managing the company, that maybe some of that has to happen a little faster to their son Alex. And then their goal again is just to preserve family wealth. This is a long-term family business. His dad, him, and now his son, and so they want to protect that for future generations. So we're down to our third generation. We've got Alex. Alex is madly in love with Julia, and they've recently gotten engaged. Julia is from a different financial sort of background. She comes from a less affluent family, and her relationship to money is very different from his. Alex is aware to some degree of the extended family wealth up the family tree. Doesn't know all of the ins and outs, but he does expect to receive some kind of an inheritance. And he's not love blind. He's fully aware that roughly 50% of marriages end in divorce, and he does want to put some protections in place because of this, family business. But he's also really concerned about how to bring that up into conversation with his soon-to-be wife. So in terms of key themes that we're going to be tackling today, is that as family wealth grows, so too does complexity. When we're blending families together, it creates planning opportunities, and it's an opportunity to get things organized now and have open communication now to ease the stressors down the road. When it comes to transitioning a family business from one generation to another, sort of good, solid coordination and collaboration between trusted partners, so accountants, lawyers, and your wealth planners, is an important piece to that puzzle. And overall, the real overarching issue and theme here is communication. So sometimes those difficult, uncomfortable conversations now can save a lot of family heartache and challenge later on down the road. So where we're gonna kind of lean to here is I'm gonna pass the mic over to Hillary. So Hillary's gonna give a high-level overview of the difference between marriage and common law in terms of the family law dynamic.
So as Megan mentioned, I practice strictly in the area of family law. So I sort of divide my practice into two sections. The first part, which is about 15% of my practice, is about the strategic planning. So I do marriage contracts, cohabitation agreements. But the bulk of my practice is really the other end, when things don't go right in the planning stage and there aren't proper protocols in place, or when individuals don't engage the panel here, because I think it's a problem, obviously, when the proper planning isn't put into place. So in terms of that perspective, I see the back end, whereas Megan, Kaylee, Blake, and Graham would help build, preserve, and transition wealth. I'm on the other end. So in terms of my approach, I might be a bit of a pessimist on the panel today because I see the benefits and the somewhat burdens without the planning piece. We've included a chart in terms of the difference between marriage and common law, and I think that's a really important place to start because there's a lot of myths out there with respect to the different rights and obligations with marriage and common law couples. I've had many people walk into my office and say, well, we've been together for 20 years, we have got kids together, we own property together, we don't have a marriage certificate, but we've got the same rights. And it's a tough conversation that I have to have with them that actually they don't. And the law does not treat them the same as married couples. And it's gonna be a bit of a harder file for us because it's going to be evidence-based. It's going to be looking at each individual asset. What's the ownership? What are the contribution? It's going to be all evidence-based. So that's sort of number one in terms of the distinction. The key differences, so in terms of married, that's the Robert and Amy. So that's Robert, who Megan described as the individual who is currently having health issues, and he's currently in charge of the business and wants to pass it down to Alex. So Robert and Amy, they don't have to negotiate their rights. They're in a married situation. The law provides that the growth between the date of marriage and heaven forbid a date of separation, that's split 50-50. Any spousal support, that's guaranteed because they're married. and they don't need to document the years of contributions. We don't need to do an evidence-based approach with that individual. And I've highlighted in terms of the different rights, we've got matrimonial home. So the first big piece is the matrimonial home. So that's a big key distinction between the common law and married couples, because the matrimonial home, as soon as that becomes a matrimonial home, as soon as you're married, that's deemed essentially 50-50. Whereas in the common law spouse, which is Susan is Robert's sister, she's, I think, dating David, but they're not yet married or don't plan to marry. That's never going to become a matrimonial home. So with Robert and Amy, the matrimonial home is deemed 50-50, and absent a marriage contract, that's essentially the law. With respect to property division, so property division, again, it's really clear. It's an equalization approach, so it's essentially a ledger. What do the parties have at the date of marriage? What do they have at the date of separation? You're splitting that 50-50. That's what the law indicates. And then in terms of pensions, that's actually a big one, because if you think about it, nurse, teacher, hydro linesman, there are a lot of great pensions out there, and that's mainly one of the biggest assets. You've got a matrimonial home, and usually it's the second piece is a pension, and when you're married, that's an automatic right, so that pension is automatically split, and that's a big distinction that doesn't happen in common law couples. And the last one is estates, which Kaylee will get into, but there is an automatic estate rights when you're married. And then you've got the common law piece. So the common law, the law doesn't really provide for common law couples right now. There's nothing statutory. I think that probably will change, given, I don't know if you've noticed, a lot of the younger generation, they're not getting married. So they're staying common law, there's no intention to marry, and as a result, the law isn't keeping up, I find. So we might see some changes in that, but at present, a lot of people are somewhat exposed, and there's a lot of assumptions. So if you're in a common law relationship, ownership is key. So if in this situation, Susan owns the home, David moves in, it's assumed that that home is going to, if they split, that Susan will maintain the home, unless David can prove there's contributions made, or that he's paying towards the mortgage, or that he's done a total renovation to the house, and that's going to be by a trust claim, which is it's sort of a gray area. So it's difficult for family lawyers. It usually ends up in litigation. And then in terms of the last one, yeah, so I talked about the pension. So there's no automatic entitlement to pension. So if David and Susan are together for 20 years and David works at Hydro One and he's got a really nice pension, there's no automatic entitlement for Susan. So that's a big problem, because these are big assets. And then in terms of, there's no automatic entitlement to estate planning either, which I think Kaylee will touch on. And then the last one, in property division. So if you've got a common law relationship, you're in a relationship for 20 years, heaven forbid there is a separation, there's no automatic entitlement to property. So a cottage that might be in Susan's name, that would presumably remain with Susan unless David then makes a claim to that. So that's sort of a highlight in terms of the differences. It's much easier to guide clients when they are married, because the law does provide a really good roadmap. And then when there's common law spouses, it's more difficult. Again, it probably means higher legal fees, because it is an evidence game, and you're sort of making a case, or you're protecting your client. So hopefully that gives you some overview with respect to the differences.
See a question in the back. Thank you for the table in the handout. That's really helpful. My question is about timing of common law. We may have received some advice that if you've been common law for 2+ years, maybe those rules move more to the marriage side. Can you comment on that?
So that's a really good question, and it depends on what the issue is. So I think for CRA purposes, I think they deem common law to be a year. And they may have changed that. CRA tends to change their mind a lot. For spousal support, they deem common law to be 3 years. So that door opens in a common law relationship if it's over 3 years, or if you have a child together. And then in terms of property, it doesn't matter if you're together 1 year or 40 years. It does not matter, because you could have a situation where let's say Susan owns the home for 20 years, David never contributed a penny. He essentially got free rent for the 20 years. And in my view, he doesn't really have a strong claim. I mean, there may be a nuisance payment, but in terms of the amount of time, just because he was with her for 2+ years, it doesn't entitle him to anything.
And I should point out that we're talking about Ontario law here, so each province deals with marital property differently. So if you've got kids living in another province, then you need to spend some time getting to know the rules in that province.
You had mentioned about the property division, and I'm assuming by the word property, we're talking about physical properties. What if it's a business property? That in a common law setting where one partner owns a business and pre-owned it going in, but then there was separation down the road.
And so this is a common law relationship? Yeah, so if it's a common law relationship, you assume the business is in that individual's name. There's no automatic entitlement to the common law spouse. The problem is that, and my take home today for everyone is going to be, if there's any concerns, I would get a marriage contract or a cohabitation agreement, because you want your intentions to be clear. But if the individual who doesn't own the business thinks, well, I did the payroll, or I looked after the children when he was building the business, there may be some trust claims they can make. And the uncertainty is difficult for the person who obviously owns the business. So it's probably wiser for them to have the discussion in advance and say, this is my business. There's no intention to share with you. Let's meet with lawyers. Let's meet with planners to get that papered.
So it doesn't have to be at the start. You haven't missed a window if you didn't do it before you moved in together. You can have that type of agreement while you're cohabitating, and then you can also have a marriage contract after you've gotten married. So a lot of people think of prenups from our friends in the South as something that you have to have, but you can have a marriage contract at any point in the relationship.
Oh, we got one in a blue shirt.
So where does income inequality fit into that? Like if the guy running the business is making $200,000 a year and his wife's making zero, is there any claims on the income inequality through common law versus marriage?
So that's what spousal support would be relevant. And so spousal support, as long as you're in a relationship for over 3+ years or have a child together, then common law, you do have that opportunity. But that would be really the avenue, is my income's $200,000, my spouse's is zero. Is there an avenue for spousal support? But there's 3 terms of entitlement. So one is contractual. It's the Tiger Woods situation. So if you're with me for 1 year, you get $10,000 a month. If you're with me 2 years, it's 12. That's the contractual basis. The other 2 are, one is compensatory, which is I stayed home, I looked after the kids, you went off and you had a great career, so I should be compensated via spousal support. And then the third one is it's called, we're not very unique in family law, it's called non-compensatory, which is if I'm living under a bridge and then my spouse is, in a lovely palace, they're going to make spousal support payable. And then you're going to look at the income. So they'll look at my $200,000 versus my spouse's zero, and it's basically a grid. It's like a meat chart.
So what happens when you go from being common law to deciding to get married? So that now the home is equal, right? What happens with the value? Like, is there anything that happens at the time that you get married? Because you were living there before common law. Is there anything that you've done in writing or anything?
So that's a really good question. So you're saying we started living together in the home, and then we got married, so it now became the matrimonial home. So one party brought in the house. Yeah, so that does happen a lot, and I think that's a really tough situation for a lot of people who brought in the house, because it's not really common knowledge. People don't think about that and understand that once you bring the house into the marriage, it's now deemed 50-50. So unfortunately, if that's still the matrimonial home at separation, you're gifting half of that to your spouse.
Yeah, and it's not, I think I was aware that probably was what would happen, but I just didn't know if there's anything you needed to do at that point in time.
Yeah, I think that's a good follow-up in that you would want a marriage contract to protect that. So typically people will say, okay, well, the house is valued at, let's say the equity in the house is right now $500,000, then any increase in that equity beyond that will be shared. But the initial $500,000 is protected to the individual who brought the home in. There's very different things we can contract in and out of in a marriage contract, but that to me is a bit fair because you sort of have to ask the questions, how are you going to conduct your marriage? If you need a new roof, is that solely going to be the person who brought the house in? If not, if it's going to be a joint purchase, then they should have some equity in the home. They should be building something, or else your spouse is never going to be inclined to put money into the home. And so you usually want to ask the clients, like, what's the intention here? How do you want to conduct your marriage? And then we can draft accordingly.
So Hillary, I have a bit of a follow-up question for you here on this. So how do you help younger clients start those conversations around, or maybe you could give a case example of a client where you did, let's work together towards having a marriage contract and the intention was clear. How do you encourage that dialogue?
So I'm finding that a lot of my marriage contracts and cohabitation agreements are second marriages or second relationships because people have a lot to lose at that point. They've been in a relationship for 10, 20 years and now, or they've been through the separation process, which is somewhat traumatic and financially difficult. So they know, okay, the second time around, I'm gonna plan for this. But for the younger couples, they have to somewhat have something to protect. A lot of people, when they're marrying in their early 20s, 30s, there's not a lot to protect there. So if you have a younger couple that, let's say, has a house or something to protect, I think it's just about communication. So having a really clear discussion. I think in our situation with Alex, he's got a responsibility to the family business. He, both grandfather and his father want to make sure that family business, there's a succession plan. So he has an obligation, I think, to his parents and grandparents to protect that. And that's probably where I'd start. It's not a fun conversation to have. We're engaged and now we have to go meet with a lawyer to protect, myself in the event of a separation. Nobody likes to think that way, but it saves a lot. Heaven forbid there is a separation, because the way these agreements are drafted, it takes the guesswork out of everything.
So a little bit of planning goes a long way up front. I've got a question here, Blake. I'm going to hand this one over to you. So when we are dealing with blended families, what are some strategies that can be used to balance fairness, protection, and independence in a way that aligns with their goals?
I think like the big thing for us on our side, right? Like the importance of like having a proper financial plan is like really key, right? Because you can get through a lot of these things. And in terms of as things evolve over time too, planning goals change. So we want to, make sure like fairness is tied in terms of like the heirs to who's going to receive assets later on. So it's more of like an estate planning thing. So when we look back to it, the big thing is just, concrete planning and then integrating that with the advisors, like your accountant and as well as the lawyers. Like we've heard a lot from Hillary. So in terms of, no, that's good. In terms of that stuff, you can kind of get a sense of the importance of the coordination to make sure that it is kind of true in terms of how it's set within the financial plan.
And I really like that it's not something you have to do from day one. You can revisit this over time. And I think the more you can be open and communicative with your partner, spouse, or with your kids, I think it's all really key. So I think we're going to move on from here to talk about our next sort of family dynamic. So here we're looking at a family cottage. So Paul and Margaret have this lovely family cottage that all three generations like to spend time at. And it's very, it's beloved. But they recognize that certainly the family cottage can bring up a lot of emotion and challenge. You've got some of your children may be interested in owning a cottage. Others may not have an appetite or the finances to manage it. So we're gonna talk a little bit about that. So Kaylee, in your experience, what are the most common cottage-related conversations families avoid, and what happens when they do?
Any family cottages out there? Nope.
Oh, there we go.
And do you know that your kids enjoy spending time there and your grandkids? Or do we just assume that they do? You've probably had a lot of great memories and hope that they have too. But that's one of the biggest things that we talk about is how do you actually have the conversation with your kids or your grandkids about whether or not they want it when you're gone. I think the assumption often is that we do want it to pass down so that they can have the same experiences with your grandkids and your great-grandchildren. But sometimes the reality is different, that they might not want it, that they might not be able to have it. So that's one of the first things that we always say is, have you had that conversation, or just assuming that that's what should happen? Which enters a little bit into the idea that we talk about a lot in estate planning is this concept of fairness versus equality. So people worry a lot about making things equal amongst their kids, but we try to talk about what's fair instead of what's equal. So you might have, if we looked at a scenario of a couple of kids, one who looks after a lot of things at the cottage, they're there all the time, but then you have somebody who's moved out of town, maybe they're even out of the province, and they're not able to be there at all and have no interest in it because they plan to be out of province for a long time. And then maybe you have somebody who can't afford it. They might love the idea of having it, but realistically can't look after it. So those are the big points that we talk about when you're dealing with the cottages. First of all, just have those conversations. So I think you'll hear that theme a lot in terms of communication and have those conversations as early as you can. One of the other things we talk about is if there's more than one child who's going to be inheriting, how are they going to be making decisions when it comes to the cottage? Are those decision-making processes going to start when you're still alive? Is everyone going to start playing a bigger role? Or do they start when you're gone? And will they have to make a decision right away after you've passed away? Or can you buy them a bit of a grace period, which we're sometimes able to build into wills as well? So you don't have to make all of those decisions right away as to what's going to happen in the future. A lot of you have probably heard of the concept of a right of first refusal in some of your business dealings. We often build those into discussions about property as well. So when it comes to the cottage, you give everybody some time to figure it out and decide what it is that they want to have happen. And there's different ways that you can plan for that and make sure it's funded in the short term. We also always talk about what happens if someone wants it. They think it's a great idea to start, but then they don't get along quite as well with their siblings as they're expecting. So what type of agreement are they maybe going to be looking to put in place so that they can come to an exit strategy if someone needs to leave? So those are probably the biggest points that I talk about when I talk to clients about cottages or vacation properties or any type of secondary property, really. Sometimes it's even a family home that's been in the family for generations, and there's maybe an assumption that the kids will automatically want to keep it in the family, whereas the kids might be looking at it as the old china that's collecting dust. They have no interest in having that be part of their inheritance. So again, talking about what it is that you actually want to see happen, and stressing the idea that the goal isn't to have identical treatment for everybody, but to have it be intentional. So figuring out what that plan should look like for your family, and it might not be the same as the person sitting next to you and what works for their family.
So Graham, can you give us maybe a strategy or an example of how, let's say, you've got Bobby and Susie and Jimmy, and the brothers want to take on the family cottage, but the sister doesn't. What strategy can they put in place to equalize that?
For sure. I think number one, Kaylee, you really nailed it on the head, this topic with the cottage, and you outlined a lot of the things that we have to consider. I want to touch first on the fairness versus equal, and then some scenarios we might see where you might think it's equal when you're distributing your assets from your estate, but in reality, maybe it isn't fair. So my thought goes to the deemed disposition of assets. So when you pass away, the government assumes that you sold all of your assets at fair market value. So a lot of the time, your cottage it's a secondary property, and especially in Ontario, they might have appreciated in value significantly. So when you pass away, there's going to be a big tax liability, and there's ways to strategize to minimize the impact of that tax, but you might leave the cottage to one child and then leave maybe your investment assets of equal value to your other child. But there's going to be a big tax liability on the one side that you might not have accounted for. So say you have a big capital gain on the cottage, your one child's going to receive that property, but the estate still bears the tax liability. So unless they're going to liquidate or sell that cottage, which a lot of the time the person that's going to receive the cottage might have an affinity for it and is not going to want to do that, they're going to have to find a way to cover the tax liability. And oftentimes, if there's not sufficient cash, they might have to draw on the investment. So even though in theory it seemed equal or fair to provide the property that's equal value to one child and the investments to the other, the investment might have to be drawn on and then devalued in order to pay the tax liability. So that's one thing I wanted to talk about there. And then some strategies you can use to kind of offset that tax liability is insurance is a very common strategy. So you might have an insurance policy. And again, you're gonna have to do a financial plan and project out the projected value of that cottage upon your eventual passing. So it's not gonna be a perfect science, but you might do an insurance strategy, and then that death benefit would be used to cover that tax liability when you pass away. So in that way, it's more fair or more equal the distribution of your cottage asset and then your investable assets to the other child.
Thanks, Graham. So I'm actually going to turn it back to Kaylee. Oh, sorry, I have a question.
So we don't have a family cottage, but we do have a U.S.
Ah.
It's kind of the same thing. It's a secondary home, but it's not even in Canada. So do we need specialized advice? Do we need a U.S. lawyer?
Yes. That is always our recommendation. Firstly, because the laws are different in terms of property ownership and the transfer upon your death. So we always want to make sure not just that it's a U.S. lawyer, but it's in the particular state that you're in, just like our here provincial laws are different. But also because obviously the tax treatment is different as well. So we always want to make sure that you're working with your U.S. and Canadian tax advisors, and then not only that you're consulting with a U.S. lawyer, but that you're probably having a will put in place for just that property. And part of that reason is, most of you are familiar, I'm sure, with the term probate, which is the official act of the court stamping your will as the final will and appointing your executors. So that happens in Ontario, usually on the second of you to pass away. But the U.S. will also, and most foreign jurisdictions, will also require a similar process. And so if we had to rely on your Ontario will, then it would make all of your Ontario assets basically open and visible to what goes on in the U.S. courts, which for some people won't matter, but for some people they don't love that idea. So by having a U.S. will in the state that your property is in, then it lets you just deal with that asset through the U.S. courts as well. So.
I was going to ask you to talk about probate, so you
Yeah.
started to do that
There you
already,
go.
so thank you. Can you maybe talk a little bit about Ontario State Administration Tax?
Yeah, certainly. So we still use the term probate because that's what most people are familiar with. It basically boils down to taxes that the government charges when someone dies. So it's gone through a number of names. It used to be called the death taxes. Apparently probate was a little more PC. And now they've changed it to the estate administration tax, but most of us still refer to it as probate. And so it is a tax that gets levied against your assets and technically your liabilities of the estate as well, and is charged at the time that you pass away. So part of the process that your estate administrator and executor will go through is looking at the value of all of your assets, compare those to your debts, and then pay the government the taxes that they're due. So right now it's currently 1.5% of the value of your assets. So most people spend a lot of time trying to avoid probate, but the reality is that it is a very small number compared to the capital gains taxes that Graham mentioned. So quite often when we have people that come to us and say, we'd like to take these steps to avoid probate, we say, well, but you're going to be charged a much higher tax percentage on the transfer of that asset just to avoid the relatively small amount of probate. So none of us like paying the government any more than we have to, and so when we can keep things out of probate, we will. So for any of you that are business owners, you've probably talked to your advisors about dual wills, which help keep your business assets and your personal assets, personal property in terms of vehicles, things inside your home, outside of that tax application. And there's other ways to provide for that vehicle as well, such as beneficiary designation. So when you're meeting with your financial advisors, when they ask you about beneficiaries for RRSPs and tax-free savings accounts and life insurance, part of the reason we do that is so that those can pass outside of your will and not be subject to probate. So the process itself is relatively simple, and any lawyer that you're working with can help you with that. And there are a lot of strategies that we can use to try to minimize it, but we always weigh whether it actually is a benefit to minimize the probate tax compared to the other taxes that you might ultimately end up paying.
So, yes.
Can you speak to if a spouse dies and the other spouse, they have separate accounts and they're not named on each other's accounts, and what you can do so that you can continue to have access to that account after the spouse passes?
We were just talking about that at lunch today, and that is a bit of a dealer's choice when it comes to the bankers that you encounter with those accounts. So if somebody has passed away and you still have separate accounts, the general rule of thumb in the banking world is that those accounts will be locked until you obtain probate, which can be annoying at its best and really, really harmful to people at its worst if you have one person who's the main income earner and one person who isn't, and they have separate accounts. Then that person can be left destitute for whatever period of time it takes you to get probate back. And we see that fairly often. So when I have people that come in and say they still operate joint accounts, we talk about why, and that is sometimes the desire to keep everything separate, which is understandable in a lot of cases. But we also talk about whether you can create a joint account and keep enough of a slush fund in there so if something did happen suddenly, you have access to funds as a surviving spouse. Another way is to put everybody on every account and pretend that you don't have access to it. So if you still want to be able to take money out, it's the opposite. So if you don't want someone to see what you paid for their birthday present, for example, you're not necessarily accessing the other person's account all the time. But I think that's the biggest thing I learned when I started estate planning is that every couple is different. They have different ideas about money that often stem from how they grew up or something that happened to them when they were younger. And they have a myriad of reasons as to why they want to keep their accounts separate or why they insist on them being joint. And they're always a good reason because they're important to that individual. So there aren't really any great ways to do it if you really do truly want to keep them separate, other than to plead the mercy of the people at the bank and see if you can get those accounts opened up.
And often you see, like, on social media, people giving advice that you can have some kind of form that you can fill out that would remain the account unlocked even if the person passes. Is that such a thing or no? Maybe that's a US thing.
That's not something that I've heard of. It doesn't mean it doesn't exist, but we probably need to talk to somebody that's in the banks, these days to know if it's a current form that we can access here.
So on the banking side, what you can see is they often have their own power of attorney form. It's not a legal power of attorney document like the one Kaylee would draft for you. It's their own form. That only applies when you have a capacity issue, not if someone has passed away. So as soon as that account owner has passed away, then you're following into the estate side of things and the will instead of the power of attorney capacity issue.
So if you have power of attorney, can you continue to have access to the account when they're deceased or no?
No.
Only when they're alive?
Yes.
You might still be able to get away with it for a while, but it technically should end when someone passes away because that power of attorney is only used during someone's lifetime.
I'm not asking for
No,
nefarious.
this is not.
You know on your banking app when you
With one going to judge, either way. So.
on your banking app when you log in and you put in your passcode and it says don't share this passcode with anybody. I mean, if you do, that's up to you, but you're not technically supposed to.
That's why you're better off, and I find first of all that the banks all have different sources, you can't get a straight answer, not the banks, but banks. But that's why you're better off to not just do power of attorney, to make the account joint. But I was told that when I went joint with my parents, because they needed that now that account, because I was joined on it, if something happened with my husband, like, he would have access to that account, so he's not on that account, I am, so that's like, I find that you just don't get a straight answer on that still. That's why the subject matter, nothing's so black and white, but it's very gray.
So who wants to take a stab at joint accounts, bank accounts, and the risks?
Yeah, so long time ago, I did work at a bank. To answer your question specifically, so in that scenario, if there's no right for your husband in that case to have access to that account because he's not on the account. So that's just, and it depends on as long as he's not listed on the account. So the one thing that gets confusing when you go to the bank and you have like a joint account, it's usually or you'll see online or you look at the legal doc, it's usually or for the banking.
Jim or Susan?
Exactly, like Jim or Susan. Sometimes you have a situation where we saw a lot, I saw it at BMO and I saw it at TD as well, where they put and instead, so you need both parties present in order to facilitate anything within the account or to make a change to the account of any material change, you need both parties present and to sign off to that. But if it's just you and it's or with your parents, let's say, then there'd be no situation there.
So there is a little bit of risk when you go joint on any account with your kids or your neighbor, that there is creditor risk there. So I'm not concerned in your particular situation necessarily, but let's say we've got, an aging parent, they go on joint with their daughter, and their daughter has her own financial troubles, or maybe it's her spouse who has, is irresponsible with money, and then all of a sudden the creditors come knocking. And so there is some risk there. So that's where Kaylee was mentioning there's a lot of activity around probate avoidance, which having that joint ownership on that account would avoid, but you can open a can of worms in terms of, I put it in joint, but now it is up for grabs if the other joint owner has financial difficulty.
Maybe one more point there. Maybe I'm stealing Kaylee's thunder, so I'll defer to her if she wants to cut me off here. A lot of the time, for the ease of administration, you'll see a parent put on maybe one of their children on the account, join, and that's the idea is, we're going to bypass probate, they have access here. But a lot of the time, from an estate administration standpoint, that account would just roll to the one child, and you might get tied up in litigation because the other beneficiary might come and say, hey, mom and dad just put you on that account for the purpose of administration. I have a right to that money as well. And then what happens is there's something called the resulting trust, which you'll have to litigate, and then maybe Kaylee can elaborate on that a bit.
Yeah, and that is exactly what we find a lot with joint accounts. So one of the things that you can do if you're considering making anybody joint on your accounts in terms of kids or grandkids down the road is you can designate at the time whether you intend for them to hold that money in trust for the other beneficiaries of your estate, so you don't have to argue about whether there's a resulting trust. You can indicate from the beginning that that's what your intention is. So really you're signaling to the courts that it's for convenience purposes. So it would still be subject to probate because you are assuming it's an asset of the estate. So you're not doing it to avoid probate, but you're doing it so you can access the account. After somebody dies, you can continue to use it as necessary. And during the lifetime of that person, you can have it be used more conveniently.
So what's the best way to document that?
It's a trust designation, so we do them fairly often. I'm sure you can find them online. It is a relatively simple indication that says, I intend for this to be held in trust. There are no formal requirements for it like there would be with a will or a power of attorney. Probably a good idea to have it witnessed, just so you know that someone knows that it was done officially. But you're just indicating that what your intention was at the time that you made that designation, that you intend for it to really remain an asset of the estate, even though you're adding someone for convenience purposes.
And if the original owner of the account, if there was, let's say they didn't think to go to a lawyer to have that done, which was probably the best, gold standard version of dealing with it, if they had their own how would sort of an email trail between like all the siblings, saying I'm putting Susan on title here, how does that stand up in court?
I can't say as to how it's doing up in court, but it's definitely not going to hurt. Again, it's that transparency and communication issue that is the biggest piece, because really it most often comes down to an argument. So the example Graham used is one child is put on the account and then doesn't want to share it with the others. So if you're saying to everyone, this is why we're doing this and this is what's happening, then it's pretty hard for someone to argue that they were supposed to be entitled to it.
So document, document, document. Yes.
If there's a trust set up, I'm just trying to think of the right word to say it. If there's a trust set up for a particular reason, but the will isn't updated. So the will is not updated. So there's a trust that's been set up, and then there's someone else on a joint account. Like, does the trust take precedent over things? Like how my mom wanted stuff to go, because now I'm in this mess. So how she wanted stuff to go was based on siblings died. She didn't update the will, but she has all these weird rules and stuff now. But I'm assuming because he's dead, everything.
So if one of the beneficiaries, it has predeceased the testator, so the testator is the person drafting the will, then that share, the predeceased child's share would fall into the balance of the residue of the estate typically. But, we would have to see the detailed documents and everything else to be able to, comment more thoroughly.
You make the decision to avoid the trust because they know like it's a Henson trust. So if can the trustee make the decision to avoid it?
No. So we would have to really look at it more specifically, but from a planning perspective, that's where having a conversation with your kids is really important when you're updating your documents. Yes.
In a situation where you have multiple children and one of the children is an administrator in either an official documented capacity or undocumented capacity, and death occurs, is there a significant risk in continuing that administration after death? Based on an executor to the will, are you putting yourself in a trickier situation? If that makes sense.
So let me just see if I understand correctly. So are you talking about someone overlaid on an account to just facilitate administrative day-to-day expenses for?
Yeah.
Okay, and then if the original owner of the account dies, then who gets to make those decisions? Is that what you're asking?
In a way, I guess more, what is the risk in continuing? Is it a hard stop where you move into execution of an executor, a will, or are you able to maintain kind of status quo for the short term to continue? Hard stop or not, I guess is what I
Legally, it's the hard stop.
understood.
Yeah. Do you have any comments?
True. If it's the same person, then you can largely continue, but you have to keep accounts of what you're doing because now you've moved into that role that is more formal than if you'd been just an administrator. Now, if you were a power of attorney prior to becoming executor, then it is the same level of documentation that you have to keep. But yeah, once you...
With the assumption you're an executor.
Yeah.
Yeah.
If you're not an executor, then it's definitely a hard stop on the administration.
So yeah, your siblings might not be very happy with you. So we're gonna, I think, park it there with respect to sort of some of the estate planning matters related to, other assets, so family cottage, other types of property. And we're gonna segue ourselves, oh no. Oh, there we go. Business succession and equalization. So, I know we've got, there's different families have different types of work. Some have their own businesses and they're entrepreneurs. Some work for government organizations and other corporations. But our case involves Robert, who has taken over the family business from his father, and they're now, working towards transitioning over time the responsibility of that company over to his son Alex. So in your handout, we actually included a checklist. So one of the questions in there is, have we considered how family businesses will transition in the future? So I'm actually going to turn it over to Blake, and maybe you can talk about what, in your experience, a well-coordinated transition of a family business looks like.
Yeah, so in terms of the complexity of this, it's not an easy thing. So I would say, I'm going to pick three things for the sake of time. So one would be communication, which has been a common theme tonight. The other would be structure, and I'll elaborate on each of these here in a second. And then the final one that I just want to hit is tax and estate planning, of course. So the first one being communication. It came up earlier in terms of the family cottage or any of these examples, but I find a lot of the times when you get in the room and you're at that point, the conversation hasn't happened between current business owner and person that's taking over the said business. Does that party want to do this for the rest of their life or actually want to run the business? And I think it's really important, you got to have that kind of heart to heart. I like to say, lock them in when you're going on a long drive and kind of hash it out if you can, kind of in some regard. But sitting on the 401 is a good way. But the communication is key. And then to elaborate on that, the communication doesn't stop there. Even at that point, you say yes, of course, but it's the communication go through the transaction, because a lot of these things take a lot of time. And then it's post-transaction too. So the communication is so crucial in terms of the success of the business, whether that be small, medium, or large, is so important. In the structure, when we look at it, it depends on the scenario, right? So of course we want to look at current structure, and when I say structure, I mean organizational structure in terms of what's important to the business and going through it in that regard. So we want to look at current structure, and then how that flows into future structure in terms of if we're doing freeze or we're making any changes at that point in time. And then this kind of bleeds into that final point of tax and estate planning. So at this time, we can really look at and working with lawyers and your financial planner, we can really project out, we can get a really good understanding of what the estate will look like at that point, so we can plan for that pending tax liability that kind of Graham mentioned earlier with respect to a cottage sale. Same thing happens, of course, when you own a business. So those are the three things that I'll just highlight right now, and then I'll pass it back to Meg there to.
So what happens when you've got two kids, a lot of your wealth is tied up in your family business, one child wants to take over the family business and the other one wants nothing to do with it? So Kaylee, how would you work with a client to solve that problem?
It again is very individual to each family and what their plans are long term. And again, this concept of equality and fairness comes up as to how estates are going to be divided. And to Blake's point, sometimes we run into situations where the shares of a company are left to one child and there's no money in the estate to pay the taxes. And we run into that situation, so there hasn't been enough planning in advance, or situations change. Maybe the investments didn't go as well as people planned. So now you have one child who's getting nothing and one who's inheriting the shares of the company that may or may not be worth a lot. But the reality is it didn't work out the way the parents had planned it or intended it to go. So that's the consideration that we're always balancing, is people trying to figure out, okay, if I give this person this piece of my estate, how am I going to balance that out down the road? So I think it's that concept, and then the other piece that we talk about a lot when it comes to business ownership is the concept of the actual shares of the business and owning those shares versus the value that's attached to those shares. So this comes up in the family law realm as well, when people are looking at how things might get divided. There's ways that we can provide for the transfer of the actual shares of the company, but then we have to deal with what happens to the cash equivalent. So the child who doesn't want to be involved in the business is probably still expecting an inheritance from that business. So is it that the child who's taking over the business will pay out 50% of that business to the other sibling? How is that going to be valued? How is the payment going to be structured over time? Is it 100% upfront? Will that bankrupt the person who's taken over the business? So there's really a lot of considerations that factor into that. And again, it varies greatly by individual families and what their long-term goals are. But I think the most important piece, other than planning in advance, is knowing that the plan might all fall apart and you need to replan. That this is a dynamic process over the course of your lifetime, and what works now might not be feasible in 5 years, either because of the economy, because of the type of business you have, because of changes in your own family. Heaven forbid, maybe something happens to the child who's taking over the business. So always think of your plan as something that's not set in stone. It's going to be changing as things in your life evolve. The other key part that we talk about when it comes to business planning is not just what happens when you die, but what happens if you're not able to run a business and are still alive. As people are living longer and hopefully healthier for longer, sometimes that's not the case, or even sometimes things happen to us when we're young that we need to make sure that there's someone in place, either through powers of attorney, which can be specific to just the business. They don't have to be the same person as the person who's looking after your personal assets, but making sure that you've provided for what will happen in that situation as well. We spend a lot of time talking about wills, but I actually think in a lot of cases, what you want to have happen will happen, whether you have a will or not, but what's going to happen if something happens to you and you're still alive and can't make these decisions yourself. So. And I would say the last piece is making sure everything talks to each other. I see a lot of people that have a really nice shareholders agreement, whether it's drafted by us or by someone else, and it's sitting in one drawer, and then they have a will in a different drawer, maybe in their office, and then they have a financial plan with their advisors, and have those people talk to each other? Do the documents all relate to each other? What are the pieces that have been taken into account? I sat in a really good education session that said you can do everything separately with the separate professionals and nothing is technically wrong. What they've each done individually in their silos is correct, but it doesn't help you if you're hoping to have an integrated plan. So I would say that's the biggest piece on the planning side for that piece.
So I'm going to use that as a good segue. So in Robert's case, he does have some unexpected health issues that have started to rear their not so attractive head. So, how does that change? I'm going to turn it over to Graham, but how does that change the urgency and structure of planning?
Yeah, in an ideal world, you'd have structure and a strategy implemented prior to a health concern coming to fruition. So obviously it makes those decisions more intimate and to the forefront. But in an ideal world, you'd have, what I think Kaylee was alluding to, maybe a buy-sell agreement if there's existing shareholders, certain scenarios that would trigger a buy or a sell event. For someone that's maybe key to the business, like Robert likely is, maybe you have what's called key person insurance. So it's insurance that the business pays for that's related to this key person. And then similarly, there could be further insurance strategies within a buy-sell agreement that help with liquidity concerns within the business Kaylee touched on, maybe there's not enough cash, they don't want to bankrupt the business in order to buy someone's shares out. What's a way to ensure that there's enough liquidity that the business continues to carry on, even if someone becomes ill or sick or ultimately passes away? A lot of the time, insurance is a great way to ensure there's sufficient liquidity within a business so that can carry on if someone is sick or passes away.
Okay, thanks. When considering transitioning the family business over to Alex, Robert might rightfully have some concerns over how to protect the business and be concerned over the long-term viability and sustainability of Alex's new relationship with Julia. So Hillary, I'm going to ask you here. So how would you advise Robert in this situation if he came to you and said, oh, Alex is getting married, he's meant to take over, what do we do next?
Thank you. So that's a pretty common issue that we approach with marriage contracts. So in this situation, Alex is 28, he's marrying Julia, but Robert, the father, has concerns. Okay, this is a big family asset, I want to protect this, I don't want half of it going to Julia. So in that situation, we would recommend to Robert, let's get Alex set up with a marriage contract. And then we have to talk about the terms. So the business, to me, is very different than the cottage scenario, because the business is not only an asset to be Alex's asset, but it's also his income source, right? So when we look at, okay, heaven forbid the marriage with Julia doesn't work out, if Robert's insisted on a marriage contract that says Julia gets nothing from the business, no income, no value to the business, I would have concerns that that marriage contract might not even stand up, because if they have children, there's going to need to be some income payable from the business for child support. If Julia, let's say, stays home throughout the marriage, she may be entitled to spousal support. That income source is still the business. So I can't tell Robert, absolutely, we'll protect your business, she will never see a dime, and nor is it fair. So you have to look at it, you have to explain to Robert, listen, Julia, if absent a marriage contract, Julia should get from the date of marriage to the date of separation, she should be entitled to half the value of that business. So if it's valued at $1 million in 2027 when they marry, and then if they separate in 2037 and it's $2 million, she should really get the $500,000, the increase from the $1 million to the $2 million valuation. So if we're going to sit down with Alex and say, okay, can we exclude that? We need to justify that to Julia, right? And her lawyer is going to say, absolutely not. The law would say you're going to get 50%. Why would you ever waive that? So there has to be some middle ground. I think Robert's going to come in saying she gets nothing. Julia's going to say, I want half, and then Alex is in the middle. He wants to start this marriage on the right track, so he's going to have to find some compromises, and it could be we insert, maybe there's a cap. I think we're never going to insert any clauses that say his income is off the table for child support. That just never, the marriage contract will never hold up, but maybe we limit it for spousal support if we can. I still think that's a bit lopsided. I mean, people can contract out of anything. So in this situation, it may be appropriate to say Julia's never going to get a value, so Alex is never going to have to equalize the value of that business. But I think from an income point of view, I think that's somewhat inappropriate.
So what I'm hearing is you can do a lot of really good planning, but at the end of the day, the laws might be different down the road, or that circumstances change, but the more you can plan ahead and ask those questions, the less worse off you're going to be down the road.
That's right.
Okay.
Hillary, I have a question for you too. In a contract, would you ever see, for example, even though there's equalization of assets, could you say, you know what, we're not going to liquidate anything within the business, but we'll share more of the personal assets of equal value? So you had a couple investment properties that have appreciated in value, and say, you know what, you get the investment properties that are valued at X, and then I get the same value in my business. You can't touch that.
Absolutely, and that protects, so essentially you're just making sure that business stays intact so that he never has to sell or impede that. I think that makes sense. At 28, I don't know if they have too many assets, but I think that makes sense. And that sort of goes back to your point, Megan, which is this is a process. So we can do this marriage contract when they're 28, hopefully well before the wedding. But then in 10 years, we may have to look back and review it. Maybe there's children, maybe there are more assets, maybe the business has been sold, so we want to update that. But I think it is a process, so we want to keep that current, because like you said, there's 3 different documents that don't speak to each other. I've got a marriage contract that doesn't make any sense 10 years into the relationship. We've got to deal with that.
And I think the other piece, when you're talking about kind of keeping the hands off the ownership of the business, if there are more shareholders in the business, quite often we'll have a shareholders agreement that says, in the event of separation, the shares are kept out of it. So it again comes to that concept of ownership versus value of the shares. So we might not have a separating spouse actually have any risk of owning shares of the business, but maybe we have another shareholder who's buying out the person who's separating to keep the business intact. So again, sometimes the feasibility of that is not there, depending on what the value is and the resources of the other shareholder. But again, it's having all of those pieces speak to each other so that we know that the business can stay intact if there's enough other assets that are available.
Thanks, everybody. I'm guessing no questions from the audience because we've been sort of doing that as we go, but if something comes up, just put your hand up and we can move on from there. So the last big focus of our family tree, and well, it looks like is family gifting. So in our case, we've got Paul and Margaret who, effectively started out with not much. When they were raising their own kids, they were working really hard and they weren't able maybe to help with home purchases or lighten some of the financial burden of raising a family for their own kids. But now they're in a position where they, that's one of their goals, is they want to help their grandchildren, perhaps buy a home. So I think we all know now that at least my kids keep telling me that they're going to have to live at my house forever because they'll never be able to afford a home. I said, ha ha ha, you're going to be an engineer and you're going to make money and you won't be able to buy your own home. So I'm dealing with that right now. Before we get into a lot of questions on this, Hillary, can you please explain the difference between a loan to your children and a gift, or your grandchildren, I guess in this case, from a family law context?
Yeah, so this is a really important issue that I'm seeing because a lot of parents are now helping children buy a home. And then, heaven forbid, the children's marriage falls apart, then we look at, okay, the first question from my point of view is, was that a gift or a loan from the parents? And I tend to view it depends on who I'm representing, is I'm going to frame it differently. So if it's my client's parents who funded the money, give the money, then it's going to be a loan, because I want to be able to give that back and not share that with the other spouse. But judges tended to disagree with me on that. So if it's a gift, the intention is that it's not going to be repaid to the parents. And obviously, if it's a loan, the parents are expecting that it is going to be repaid. That's a pretty simple concept. But with respect to how the Family Law Act works, if your child has received a gift during the marriage, so if Alex and Julia marry 2026, parents gift Alex $200,000 for the down payment on a home in 2027. That's assumed to be a gift, and that's if it was 200 cash, that would be excluded from a separation. So the 200,000 would not be shared with Julia unless that money goes into the matrimonial home. So, and that's what people are doing. They're taking that 200,000, they're buying their first home. So the exclusion is lost, meaning Robert has now gifted Julia $100,000 because the equity in the home is, if it's 200, he's given her half the value. So the problem that we see is there's no documentation with respect to the intentions. What happens is you have a dinner out with your parents and they say, okay, we've got some money, we'll give you the 200,000, or we'll give you the 200,000 for the home. Nothing's documented. And in fact, when Alex goes to buy the home and he says to the bank, I need a mortgage. I've got $200,000, but I need a mortgage to the balance. The bank says, okay, where's the $200,000 from? It's from your parents. We actually want your parents to sign a gift letter. And so now it's not even the choice of Robert or Alex, it's the bank making the decision to say, okay, this is a gift letter. The gift letter typically says, Kaylee knows more about this than me, but it says this is a genuine gift. There's no expectation of repayment, and no part of this is a loan. So then that is going to be evidence for a judge one day. So keep that in mind. So now everybody's thinking this is now a gift. And so how does that flow through in the event of a separation? Okay, Robert gives Alex and Julia, Alex $200,000. They buy the house. They then separate. And on the other end, you've got $200,000 equity in the home, and they separate. Julia's getting $100,000. So Robert's gifted her $100,000. Half the inheritance is gone to Julia. Whereas if Robert said, I'm going to loan Alex $200,000, and that's got to be well documented, and heaven forbid Alex and Julia, their relationship breaks down, the loan is repayable to Robert. So that $200,000 has to be paid to Robert. Now there's no equity in the home essentially, but Robert gets paid back and nothing goes to Julia. So that's how it plays out in terms of a separation. But I think in terms of the importance, I just lost my train of thought. What was your initial question? Just the difference. Okay, so the difference is pretty clear. Okay, yeah.
So I'm going to turn this to Kaylee. So how do you assess whether support should be structured as a gift, a loan, or a future, like a early inheritance?
So to Hillary's point, it depends on the intention of each person. Some people really do want it to be a gift, no matter what we tell them that means in the event of a separation. Some people recognize that they wanted to stay with their family versus be divided between them and a future ex-spouse. And in that case, it will be documented as a loan. Hillary and I have actually been going around this conversation the last couple of weeks where someone is loaning money to their siblings. So it's not even a gift to children and grandchildren. It might be you've come into some money, the sale of a business. Now is a good time to let people benefit from the gift that you've given them during your lifetime. So as Megan said, you get to see the smiles and enjoyment and make their life a little bit easier. So in that case, we have a promissory note, so we're documenting it as a loan, but we're having both parties sign it so that when, if they separate, I shouldn't say when, I'm jinxing them, sorry about that, guys. If they do separate, then that loan is payable from both of them. It goes back to the person who's making the loan, so a parent or grandparent, and then you can choose to gift it to your family member after everything is settled. So that's quite often what the recommendation is. Sometimes people talk about mortgages. So obviously we prefer if money you loan someone is secured, just like the bank does. The problem is the bank doesn't always love us putting a second mortgage behind their first mortgage. That can actually put you in default of your existing mortgage. So if you have someone encouraging you to just put a second loan on any property, please think very carefully about that and make sure you're talking to your bank about it. So quite often these promissory notes are unsecured, and if someone didn't pay you back, you'd have to enforce it in court, but at least it's documented. Everyone knows what the understanding was. It's clear and obvious at the time that the money was transferred. The concept of having it be an advance on someone's inheritance is one that we see quite often. So if you've got maybe a child or a grandchild going to medical school, for example, overseas, that's quite a common one, it seems. Very expensive, it turns out, to go to medical school in Ireland. So if you've loaned $200,000 to someone for medical school and your other child hasn't had quote unquote need for the money, it can be pretty hard to equalize that during your lifetime. But parents, of course, are worried all the time about making things fair. And so we talk about how you can bring that into account at the time that you pass away. So if we're doing that type of advance to people, again, we might evidence it with a promissory note, but we would say in that note, this is intended to be an advance on your inheritance and will be forgiven at the time that you pass away. Or it can say it won't be forgiven, and then it gets taken into account in that manner and essentially deducted from what that person would have received from the estate. We also have the concept of what we call a hodgepodge clause, which I think is one of the strangest terms that they have in estate planning, even though there are a lot. And again, it's just a shorter word to describe bringing things into account. So it's actually quite a wordy paragraph, given that the name is so short. It says, when we pass away, we're going to equalize things between all of our beneficiaries. So that's one way that parents are able to do that in advance. Yeah. Sorry, I've just got a question.
Ruling out a marriage breakdown or excluding it, is gifting or a loan a favorable strategy to reduce probate on an estate?
It would effectively reduce probate if it was a debt against the estate. So that is one consideration if you're looking at how you're going to do it. So
Not a gift, a debt.
a gift wouldn't, because it's essentially gone from the estate. It would have to be a debt. Yeah.
Just on that note, though, if you already gifted the money in advance, it's not part of it.
Oh, fair enough. It would reduce it because it's not there.
Right.
Yeah. So you're right. It does effectively do it in that sense as well. Yeah.
So when we're working with clients who are maybe, there's one child who has a bit of a heftier financial need during their parents' lifetime, we encourage clients to really keep track, a detailed record of any gifts that they've made in life, so that when, if they do have that hodgepodge clause in their will, then there's documentation to show exactly, what was given. We can say here, if Robert was given money versus Susan or vice versa, keep a good detailed record of that. And then an even better step forward would be to have that child who received the funds sign that ledger or sign a letter to say, yes, this, mom did gift me this, and I understand the intention is to equalize through the estate using a hodgepodge clause.
How much can you gift a child while you're still alive and not, and there won't be any tax implications for the person receiving it? Can I gift each of my children $100,000 and it's not going to affect their income tax?
That's my understanding.
That's correct. Yeah, in Canada, that's correct. In some different geographies, that's not the case. Like you may be, from friends, and it sounds like you have a property in the U.S. In the U.S., there is a gift tax. It doesn't affect you, but that some people think that the rules apply across the borders. But in Canada, no. If you give a gift, there's no tax implications for that, unless you're selling an asset in order.
And no tax to the child, so they don't have to claim it as income.
Was there?
Well, I was just going to say, in our situation, we're a blended family, so we did, and like Eric, we did a tab system, so that every child's need is different, and my techie husband made an app for it. Every child has to submit a receipt, and it has to be agreed upon by us, and then the funds get given, and it goes on a tab to what will ultimately come off their inheritance.
Okay.
So it's like a living will, but it's each child can only see their tab, but they fully know, and they're responsible for documentation, so we're not chasing them, and it works for them.
That's a really, really cool strategy.
I know.
To patent.
Yeah, you should patent it, actually.
Lorraine is very good at keeping everybody organized. I will say there is quite a bit of administration there. So
I think we've kind of covered a lot of what we wanted to on this particular topic. If there aren't any more questions, then I'm going to sort of move on forward. So we're coming toward the end here of our plan. I think that's my last slide. It's clear from the cases that we've discussed today that tax, financial planning activities, and legal activities, they all overlap and intersect. And there's also different ways of solving different challenges. So there's no perfectly one right answer. So it is important to get perspective from the different trusted advisors in your sphere. So I'm going to ask Graham this question. What happens when families, and we've kind of touched on it, but when families approach their planning in silos rather than one integrated effort?
Yeah, I think we have touched on this already, and I think Kaylee spoke to it very well. You have to ensure that your accountants, your lawyers, your wealth advisors are all working in unison to ensure that your intentions are clear across all parties and in all documents. So even though you may intend for something to be inherited by a child, maybe your beneficiary designations on your registered accounts don't align with that intention. Maybe you were trying to do some tax and income splitting strategies through a family trust, and it's set up with your lawyer, and it's managed somewhere else, but they don't realize you have to pay an interest charge on an annual basis in order for those tax benefits to continue. So I think what happens if there's not clear communication between different parties and it's siloed, your planning becomes disjointed, it becomes sometimes ineffective, and then ultimately when you do pass, it might lead to conflict between your beneficiaries because you may have communicated to them, this is what's going to happen, but the executor might say, you know what, that's not documented here, I have to go by the beneficiary designation, for example.
How do you recommend bringing all those people together as a best practice?
So what we do, and I think it works really well with some clients, is we say, you know what, on an annual basis, we might meet more than annually with you on your wealth or your planning. On an annual basis, why don't we sit down with all the parties, all the professional parties that you have in your life, whether that's your controller in your business, your lawyer, your accountant. Let's do a longer than usual meeting, a 2-hour meeting, and let's all get in one room and have that conversation together. We've done it a few times. It works very, very well. Everyone's on the same page. And then expanding on that point, what can be really beneficial as well, and sometimes people aren't as comfortable doing it, is having these generational conversations with the different generations in your family, saying, you know what, we're getting to an elevated age. We want everyone to know what our assets are and what our intentions are. Let's sit down. Maybe it's Christmas. Maybe it's sometime in July at the cottage. Let's sit down. Let's talk about what our intentions are, what our legacy is. Maybe we want to do some philanthropy together and have those conversations. So just organize a set date to get together with those professionals, and I expanded on that, or with your family to have those conversations.
If you have enough of those meetings, there'd be no assets.
There you go.
So we will often facilitate those family meetings too, if a client is open to that. And then one thing that we do as a practice is we send out meeting notes after the fact. So it is documented, and we will send copies of, we'll copy the kids who were present at that meeting in those family meeting notes so that everybody is very clear and there's a paper trail. So later down the road, Bobby can't say, well, mom told me this, but we say, oh, well, you received the email, you didn't have any questions. It's not foolproof, but it certainly provides an added layer of protection. So I'm going to ask Kaylee this one. So what are the signs that families are avoiding conversations that they should be having, and how do you help to encourage those conversations?
I think one of the biggest ones we see is the people that say they've been meaning to update their wills. That to me is usually a sign that something has changed, and either they're not taking the time or not making it a priority to do it. And we get it, everyone is busy. Most of you have businesses or jobs that keep you very, very busy, and it's hard to take the time to do these things. But that is one of the signs to me. Otherwise, it might be comments like, we'll get to that when we retire. We'll look after it later. We'll even things out as we go along, talking about money that's been loaned to the kids. As we all know, sometimes the universe has different plans for us, and we don't always get the time that we think we have. So whenever we hear those comments, we encourage people to have the conversation sooner than later. As Graham said, it might be, at a family get-together. I always say it's much easier to have the conversations now when everyone's healthy and happy than it is to have them over a hospital bed. And I've been there for both types of conversations, and I can certainly tell you which ones go smoother for everyone. But I think a big piece of it is trying to encourage people that the goal is not just to give away your stuff. I know we've all worked very hard for the money we have, the businesses that we've built, and the intention is to leave a legacy. But I think for most of us, the legacy is a family that gets along long into the future after you're gone. And sometimes, depending on how things get divided, that is not the case. We have a very healthy estate litigation department for that reason, because things fall apart, particularly when the second parent goes. I find that when the first parent passes away, the kids kind of hold it together until the second parent is gone, and then the gloves come off. One of my favorite graphics that I use when I present is a father sitting behind a big wooden desk, and his 3 kids are on the other side. And he said, there's not going to be any problems after I'm gone, right? And the bubble above the kids is saying, no, Dad, of course not. But one of them has an axe behind their back, the other has a shotgun, the other has a mallet. And it's very true. And these things don't even boil down to the money a lot of the times. It doesn't matter what the size of the estate is. We see issues in big estates and small estates. It boils down to who thought their parents loved them more, who got a pony when they were 10 years old and who didn't. And these things have been festering for a really, really long time. And those are, I think what we spend a lot of time talking about is, how do you think your kids will get along as executors together? Should they even be working together? Should you use a corporate trustee or someone completely independent? How do you think they'll get along when they're all owning a cottage or a set of investment properties or a business? And then have those conversations now so that they can hopefully preserve those relationships long after you're gone.
That's great advice. So I'm going to have sort of one last closing question, and I'll let each of you kind of weigh in. But what's one conversation families should start this month rather than someday? So I'll start with Graham, and then we'll work our way back over here.
It's a tough one. I think what it comes down to is what I mentioned about having those family governance conversations, sitting down. Just make it clear where your intentions are. This is what we'd like to happen. Here's how we see it coming to fruition. And then have those tough conversations early.
Thanks. I would definitely agree. I think from my perspective, I would probably just advise to just invest in this. Like, I see a lot of people who come in and they start off in the consult wanting a marriage contract because maybe their real estate lawyer said it was a good idea, and then they don't really want to follow it through. They don't want to spend the money because, of course, this marriage is going to last, and then the document never gets signed. And I think it's important that these documents are finalized, because they do save a lot on the other side. And I think the second piece is really, we are seeing people come in with AI drafted agreements or online agreements, and they come in and they're relying on that. This is my marriage contract. This is what, lawdepot.ca spit out 6 years ago, and it's not reliable. I don't think that's, a good alternative. There still is a lot of merit to meeting with individuals, to having a plan, to getting this process done, and to having it evolve throughout the life changes that are approaching. That's sort of my advice.
I would say challenge your advisors. To your point earlier, I think it's really important to, one, understand what you're doing, but you have every right to challenge us up here, your financial advisor, and I think the industry, from the client's perspective, has become complacent, and I feel that you have every right to challenge to have more for what you pay for from our perspective. I can't speak from a legal perspective, but I can speak from an accounting perspective as well as the wealth management perspective, and I think that's really important, and I think you guys have every right to challenge your advisors to make sure that you're getting the outcomes that you think, that we know that you deserve, kind of thing. So.
And I bill by the minute, so you're going to get charged.
Well, and I do think the point that was made earlier that having everyone involved is more expensive, but it is probably less expensive than what the repercussions might be if things don't line up. So, I've been in the shoes of the people paying for legal fees and accounting advice. I know what that's like. But I think for me overall, I don't care which conversation it is you start, but just have it. I think we've all heard the saying, the best time to plant a tree was yesterday and the second best time is today. So if there's a conversation you've been putting off, if you haven't looked at your wills in a while, if you were intending to document something that you've loaned to a kid, pick one of those things and check it off the list and just get it taken care of.
Thanks, everybody. So just in wrap up, if there are no more questions, just really appreciate you taking some time to spend with us this evening. Hopefully there's a few little nuggets of wisdom that you're going to walk away with, or a little bit of motivation to get on that to-do list that we all seem to sort of park because, more interesting, exciting things take our attention. So inside your handout, we did include the family planning wealth checklist. Not sure what's happening with my computer. But it's sort of meant to be something that you can use as a guide to open your mind to different sort of points that maybe require clarification or some action. We're going to stick around here for the next little bit, and so we're available if you have additional questions. There's still a little bit more food. Have another drink if you'd like. Our website and contact information is also on, so the Barriston one and the Sunnydale Family Wealth websites are on there, and our contact information can be found through there. So if you go home and you're thinking about something else, after tonight, please feel free to reach out, and any one of us would be happy to talk to you. Thank you.